Hello everyone, this is Crypto BitLaw back with another blockchain legal brief, and today we're going to be covering how a former SEC official recently came out and made a statement to the effect that he believes that the SEC will end up losing the Ripple case on the merits, right? So we're going to be doing a deeper dive into this and kind of seeing why he believes that and what his reasoning is for that statement. But before we dive in, please, if you enjoy this content, hit that like button, subscribe to our channel. And if you'd like, you can also follow us on Twitter. Our handle on Twitter is @CryptoBitLaw. So with that said, let's dive right on in and see what this is all about. All right, as we can see here, Cointelegraph reports that former SEC official predicts regulator will, quote, lose on the merits of the case against Ripple. Joseph Hall believes that the SEC is not yet equipped to handle litigation in cases concerning cryptocurrencies as securities yet, making it hard to win the case against Ripple. A former executive from the United States Securities and Exchange Commission believes the regulator has a good chance of losing its $1.3 billion lawsuit against Ripple on the merits of the case. Attorney Joseph Hall has also voiced concerns over what the SEC's endgame could be regarding the high-stakes case against Ripple, which will have ramifications for the entire industry. The lawsuit alleges that the company and its co-founders, Brad Garlinghouse and Christian Larson, failed to notify the SEC about its sale of XRP beginning in 2013 and that the tokens are unregistered securities. The SEC has been trying to prove that securities fraud took place as a result. Hall, a former managing executive for policy at the SEC, appeared on the Thinking Crypto podcast with host Tony Edward on Tuesday, where he said, quote, I'm not entirely sure what the SEC is planning on proving in the XRP litigation. The implications for the SEC and the crypto industry as a whole are massive. As Hall puts it, quote, the SEC has a lot riding on this case, and their entire regulatory project could basically be shut down if they lose on the merits of the case. He continued, quote, and I continue to think that there is a pretty good chance that the SEC will lose on the merits. Hall believes that Ripple has a strong defense based on the basis that the SEC failed to give fair notice of its investigation. The SEC is required to notify individuals and corporations that they are being scrutinized. Quote, I'm very sympathetic to that argument. It's a basic due process argument. The Ripple network was operating for years before the last-minute filing of a lawsuit against them. Jeremy Hogan, another attorney who has been following and commenting on the Ripple case for some time, also believes that Ripple's fair notice defense will be strong enough to keep it out of the proverbial fire. In a Wednesday tweet, he cited a precedent from the case the SEC brought against Liberty Credits, LBRY, last March that was stricken because the SEC failed to give fair notice. Here's the tweet from Jeremy Hogan where he says, in the LBRY case, Liberty, we'll just call them Liberty, actually asserted a fair notice defense, and not only did it not get stricken, the SEC didn't even try and strike it. So, how a trial-level court striking a completely different affirmative defense in that case is irrelevant, I don't understand. They say the Ripple case could have effects that set the tone for investigations and litigation in cases regarding cryptocurrency for the foreseeable future once a ruling is made. If the SEC wins, it could begin a deluge of new investigations and court cases against crypto projects. If Ripple wins, it could force the SEC to drastically curtail attempts to go after the crypto industry. So my thoughts on this are, there's some interesting points taken. In terms of this Liberty case, I think that it's good to have a precedent where you have a different entity, this Liberty group, that actually asserted a fair notice defense and it actually stood up, right? So it didn't get stricken down and the SEC didn't even try to take it down. So the fact that this held up before sets a good precedent for the Ripple crew going forward. On the other hand, based on the recent developments in this case in terms of the SEC trying to eke out information that attorneys at Ripple had internal communications to executives and other individuals at Ripple Labs regarding the fact that Ripple, or XRP, the XRP token, could have been considered a security, does not bode well for Ripple. But ultimately, that information has yet to be weighed and considered by the courts in terms of whether or not that is going to be a determining factor of how this case will end up shaping out on the merits, right? So, Pretty much we're still at the same point as we were about a week ago, where we're waiting for these two developments to play out, the fair notice defense and the SEC's counter that Ripple had foreknowledge that XRP, the XRP token, could be considered a security. It may likely have been considered a security. In terms of where we are in the docket, let's take a look. This is the docket, as we can see here. It's been going Securities and Exchange Commission versus Ripple Labs. This has been playing out for a while. We're going to link this down in the description below, of course. But most recently, we have an order right here regarding a letter that was filed and proposed redactions to exhibits, and then a letter motion for leave to file a reply, and then a letter addressed to the judge that's a response to the SEC's motion seeking leave. So pretty much this is just typical litigation, back and forth, back and forth, back and forth. Oh, we want to file something. Oh, no, we don't think you should be able to file that. Oh, court, please, can we file this? And then they'll have a hearing on it, right? This is the sort of back and forth. Oh, you filed something, but I think it needs to be redacted because you shouldn't have filed that exhibit as part of discovery. And it just keeps on going back and forth and back and forth and back and forth until finally, after all of this, you finally get to the point where you actually either one party has so much leverage over the other party that they're going to force a settlement, or the case actually goes to be heard on the merits, and the fact that one party has leverage over the other one doesn't bode well for the party that is leveraged in court, and they end up losing. So as to how this will shape out, only time will tell. I know that we're tracking both of these current developments, the fair notice defense and the counter from the SEC that Ripple had foreknowledge that the XRP token would likely be considered a security. So we're going to see how this plays out, and we're going to keep you guys updated as to how this is shaping out going forward. But I guess with that said, hopefully you guys enjoyed this content. Please let us know what you think down in the comments below. If you have any suggestions for new topics you'd like us to cover, we'd love to hear that. We'd love your feedback. Again, yeah, if you like this content, please hit that like button and subscribe to our channel. And with that said, thanks for watching, and we will see you all in the next video. Thanks again.